Appearance on Dion's Daily Dose does not imply endorsement from or by any candidate or guest. The views, thoughts, and opinions expressed by Dion Bergeron or Dion's Daily Dose are his own and do not represent the views, thoughts, and opinions of any guest. Material and information presented is for general information purposes only. The Dion's Daily Dose name in all forms and abbreviations are the property of its owners, and its use does not imply endorsement of or opposition to any specific organization, product, or service. If you'd like to support the show, please visit our Patreon at patreon.com/Dion'sDailyDose.
Welcome, ladies and gentlemen, to today's episode of Dion's Daily Dose. This is Face to Face with Dion and Shawn. I'm Dion.
And I'm Shawn.
Welcome, Shawn. As always, it's a pleasure. We have an interesting story for you today that I did not find except for one place, and that was Truth Social. Now, the author of it is John Solomon, and I've heard of him.
I have too,
but I'm not deeply familiar with his work. Didn't he used to work for Fox at one point?
He was a contributor.
He was a Fox.
He comes on Fox every once in a while.
Okay.
Still, I think he's the creator of JustTheNews.com.
Yes. Okay. That's where I know the name from. Okay. So JustTheNews.com is I've seen some stories there that are all very well sourced. So I'm not super familiar with the site, but I did run across it and I did want to share it with you. There are some links that lend credence to what the story says. But let's get into it. The short version is that the prosecution in the Mar-a-Lago trial, which is where they raided Trump's house and said, oh, you stole these documents. These are classified. You shouldn't have these, et cetera, et cetera. The allegation is that the story says is that when they collected the evidence, they marked it in a certain order. And now when they're going through it, it's in a different order.
Really?
Yeah. Now, what this opens the door to prosecutorial misconduct.
Yeah.
It opens the door to evidence tampering. It opens the door to a lot of things. It may just be as simple as, we'll get into it, but the explanation is, well, there's little stuff in there that gets shifted around. Now, maybe that's possible. However, one of the most critical pieces of any trial is the evidence. And if the evidence is compromised, well, that certainly leaves a lot of room for reasonable doubt, doesn't it?
And the Presidential Records Act, which they're going after him for, isn't clear, crystal clear. There's a lot of gray because former presidents have taken documents before.
Didn't they, as I recall, didn't they have that problem with Obama? Didn't he take a whole bunch of documents he wasn't supposed to have?
I believe, yeah.
Yeah.
And then we got Biden, who just left them in his house in Delaware.
Yeah.
And also the Penn Center.
Which one of their biggest contributors is a little country we like to call China.
Yep.
Yeah. So, ladies and gentlemen, let's dig into this. It's an interesting story. Here we go. I hope that you'll find this as interesting as we do. So up here, the headline, Trump whodunit. Prosecutors admit key evidence in document case has been tampered with. Legal experts call revelation a, quote, serious violation, as Jack Smith's team admits it also misled the court.
Oh.
That's a big deal. It is a very big deal. Go ahead.
Judges do not take time.
No, judges don't like that at all. They do not like to be misled. In a stunning admission, special counsel Jack Smith's team is admitting that key evidence in former President Donald Trump's classified documents criminal case was altered or manipulated since it was seized by the FBI, and that prosecutors misled the court about it for a period of time. Dun, dun, dun. Legal experts told Just the News the revelation could prove to be a serious problem for prosecutors and a violation of court rules to preserve evidence in the state it was seized. And they're not talking about Florida. They're talking about like state as in the way that it was collected. It needs to be the same. When you collect something, in order to preserve it, it needs to be the same. That includes the order of things. In a new filing Friday, Smith's team said that the order of documents in some of the boxes of memos that were seized by the FBI from Trump's Mar-a-Lago estate was altered or jumbled, leaving two different chronologies. One that was digitally scanned and another the physical order in the boxes. They do not match. That's the problem. Quote, since the boxes were seized and stored, wait, who is this? Hold on. Oh, it's Smith's team. Hold on. Since the boxes were seized and stored, appropriate personnel have had access to the boxes for several reasons, including to comply with orders issued by this court in the civil proceedings noted above for investigative purposes and to facilitate the defendant's review of the boxes, Smith's team wrote in a new court filing to U.S. District Judge Eileen Cannon. I don't know if that's how they sound, but it's how I imagine they sound. Quote, there are some boxes where the order of items within that box is not the same as in the associated scans, the prosecutors wrote. And say that again. Not like that, though. There are some boxes where the order of items within that box is not the same as in the associated scans, the prosecutors wrote. Now, that is a very serious problem. Those listeners not involved with the legal field may not realize what a huge problem that is. Smith's team, in a footnote, also conceded it had misled the court about the problem by previously declaring that the evidence had remained in the exact state it had been seized. Wow. Dun, dun, dun. So they lied to the court. This keeps getting better and better for this Jack Smith guy, don't it?
Yeah.
Holy cow. Quote, the government acknowledges that this is inconsistent with what government counsel previously understood and represented to the court, the footnote said. That's the actual quote. And I would say that's a pretty darn big deal.
Yeah.
We acknowledge that we lied.
Yeah.
We acknowledge that, yeah, we told you it was like this, but it's not really. You can read the filing here, which we'll look at in just a moment. The organization of the documents in storage boxes at Mar-a-Lago is likely to be an important part of Trump's defense. His team is expected to argue the documents were stored in the White House in chronological order on the days that Trump received them, and that staff simply boxed them up and sent them to his home without him accessing them or knowing they contained classified information. I also, as an aside, I don't know if I sent it to you, but the FBI admitted that something was off about these boxes. They basically, the FBI went through stuff and then sent it. Essentially, the FBI are the ones who sent these boxes to Trump and then came and seized them. Did you see that?
I did not, but that sounds like maybe a setup.
Yeah. Oh, yeah. We'll cover that story in a little bit. Smith's team tried to downplay the problem and argued it's not a reason for a delay in Trump's case. Yeah, lying to the court's not a big deal at all. Mishandling evidence is not a problem.
Tell any judge in the country that.
Right. But several legal experts told Just the News the court filing essentially is an admission of evidence tampering and could be problematic. Well, I'd say so. Quote, prosecutors and investigators should never tamper with or alter evidence in their possession, including the order of documents in a box, because one never knows what may become relevant or crucial to a court or jury later in a case.
Yeah.
Harvard law professor, how do you say that? Emeritus? I think it's emeritus.
Dershowitz.
No,
Is it Dershowitz?
this one. Emeritus, Harvard law professor, emeritus.
I think that's how you.
Alan Dershowitz said.
Okay.
Prominent defense attorney Tim Parlatore,
Never heard of him.
I don't know, who worked on Trump's team earlier in the classified documents case but no longer is involved, said, quote, this admission is stunning on multiple levels.
It is.
He said the revelation, quote, reinforces the incompetence of prosecutors in conducting basic criminal investigations and prosecutions that I observed when I was on the team. But at a deeper level, the loss of specific document locations is a destruction of exculpatory evidence, he added. Ooh. I went through all of the boxes at NARA, and the document order was important because it was clear to us that the boxes had been untouched since leaving the White House. Now, that is a critical piece of exculpatory evidence. Interesting. Quote, for prosecutors who are trying to prove that the defendants knowingly possessed these documents to then destroy the evidence that would undermine that claim is a very serious violation, he added. And I agree with that because let's face it, if the boxes are in their exact order, the documents and stuff inside the boxes, the contents of the boxes, if it's in the exact same order as it was when it left the White House, it's pretty self-explanatory that nobody touched it. Nobody messed with it. So if they're now different from the way they were collected, someone did something with them. Smith's team, of course, tried to downplay the problem, offering several explanations for how the documents and their order could have been scrambled since the government took possession of the boxes. Quote, there are several possible explanations, including the above described instances in which the boxes were accessed, as well as the size and shape of certain items in the boxes, possibly leading to movement of items, the prosecutors wrote. For example, the boxes contain items smaller than standard paper, such as index cards, books, and stationery, which shift easily when the boxes are carried, especially because many of the boxes are not full. The alteration of evidence has been an issue in earlier political scandals and prosecutions in Washington. Erasure of an 18.5-minute segment of Richard Nixon's White House tapes became a very important aspect of the Watergate scandal. The Iran-Contra scandal exploded during the Reagan years with the revelation that documents were shredded before they could be obtained by investigators. I remember that. You remember that? The Iran-Contra deal?
I don't remember, but I read about it.
Yeah, a little too young for you.
I was like
for that.
a year old.
Yeah, fair. The Hillary Clinton classified email scandal became more complicated in 2015 with the revelation that her team used a bleach bit program to erase emails on her secret computer server and had email devices destroyed.
Yep, I remember that.
Let's go take a look at this. Let's take a look at this document here. So apparently they seem to think it's perfectly all right to just have the stuff wherever, whenever, right? Doesn't really matter. It's all good, ladies and gentlemen, because we're totally in the right here on this Trump thing. We absolutely, positively would never do anything untoward or politically biased to attack Donald Trump.
Never.
We've never seen that happen.
Ever.
All right, so here's the document itself. It is United States District Court, Southern District of Florida, West Palm Beach Division. The case number here, if you care, it's 23-80101-CR-Cannon, CANNON, with a little S in parentheses afterwards. Don't know what that means. United States of America plaintiff v. Donald J. Trump, Waltine Nauta, and Carlos de Oliveira, defendants. Here's the government's response to defendant Waltine Nauta's motion to extend time. Blah, 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 blah. I'm actually looking for, let's see here. Okay, so this, okay, you know what? Yeah, let's just read the whole thing. We're kind of burned through it real quick. All right. On April 10, 2024, the court set a May 9th deadline for defendants' expert disclosures and notice pursuant to Section 5A of the Classified Information Procedures Act, CIPA. See 18 U.S.C. 3, Section 5A, E, C, blah, blah. 3 weeks later, on May 1st, defendant Waltine Nauta moved for an extension of the deadline, ECF number 507. Originally, Nauta had counted on leveraging his counsel's vacation and trial schedule to delay the proceedings. But when his counsel's trial schedule excuse evaporated, Nauta was forced to devise a new basis that the government's discovery is insufficient for him to identify the classified evidence he wants to disclose at trial and to notice any expert testimony. Nauta's latest basis for delay is both factually wrong. The government has afforded Nauta technical support, indexing, and material not required by the federal rules or provided in most criminal cases, and legally baseless. The shortfalls Nauta alleges do not impact preparing a CIPA Section 5 notice or a Rule 16 expert notice. The court should deny his motion. So you can tell this was filed by the prosecution. Introduction. In his motion, Nauta resorts to a familiar tactic by trying to paint a confusing and misleading picture of the state of discovery. But at the bottom, his arguments are uncomplicated. First, as to CIPA Section 5, Nauta claims that he cannot make the required disclosures without knowing, quote, for certain, A, which documents produced in classified discovery were recovered from boxes in the storage room, and B, where those documents were found in the boxes. All of that was direct quote from the document. I'm going to pause here for just a moment because I see where this is going. Now that we've read the story and we're diving in, the prosecution, it looks like, are trying to say, oh, it doesn't matter what order the stuff's in. It doesn't matter. All that's irrelevant. It doesn't matter.
And it is relevant.
It is extremely relevant. ECF number 507 at 10. I don't know what that means. Both claims are flawed. The premise of the first, that Nauta has not been informed which documents came from the storage room boxes, is inaccurate. Nauta was provided that information many months ago. The conclusion of the second, that Nauta needs to know where the documents were within each box in order to make a CIPA Section 5 disclosure, is recently manufactured and not credible. Okay, let's keep going. Maybe they make a point. With respect to expert notice, Nauta claims not only that he is unable to meet the court's May 9th deadline, but also that it is premature for this court even, quote, to set any deadline. ECF number 507 at 13. I don't know what those are. ECF, I'm not, electronic court filing number, probably.
That's probably what
That's what it is, yeah. The prospect of experts being an issue in this case has been apparent since indictment, and a scheduling order the court propounded as early as July 2023 included expert notice deadlines for the government and the defendants. See ECF number 83. And the government timely filed its expert notices in January 2024, nearly 4 months ago. See ECF numbers 215, 256, and 257. Against this backdrop, Nauta's lobbying an argument 8 days before his notice is due that the court should not have even set a defense expert disclosure deadline readily reveals his true purpose, injecting needless delay. But, as discussed below, his alleged basis is also meritless. Nauta claims that he cannot be expected to identify or disclose experts because, quote, The special counsel's office has yet to provide forensic images of the devices for which it has proffered expert testimony. The claim is inaccurate and misleading, as the government has explained elsewhere. See blah, 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 blah. In August 2023, the government provided Nauta with the unfiltered and unscoped forensic extractions of his two phones, complete with Celebrite reports. I don't know what Celebrite is. See Exhibit A attached here too. And as detailed nearly 4 months ago in the government's notice of expert disclosure, let's see these various things. Since one of the phones contained 2 unique images with classification markings, the government provided those images separately to defense counsel via classified discovery in October 2023, along with the related forensic report containing metadata relating to those 2 images. Nauta has everything he needs to identify an expert and has had it for several months. Argument 1. Nauta is adequately equipped to provide a SEPA Section 5 notice. The purpose of SEPA Section 5 is simple: to require notice to the government and the court of any classified information a defendant expects to disclose at trial or a pretrial proceeding. Nauta has known for months that he would be required to provide such notice, and as discussed below, he has for months had access to the information to equip him to do so on the court's schedule. A review of the procedural history underscores his gamesmanship. Wow, these are like just wow. These don't read like typical court papers.
No.
Like they're very like, I don't know, just very right? A, procedural background. At the time of its first introduction of unclassified discovery to each defendant, July 6, 2023 to Nauta, the government informed the defense that it could contact the government to arrange for inspection of unclassified items seized during the August 8, 2022 search of Mar-a-Lago. See these numbers. At no time before the first SEPA Section 5 notice deadline of November 17, 2023, nor for months afterward, did Nauta contact the government to schedule an inspection. Instead, Nauta waited nearly 8 months to do so. The government arranged for Nauta's counsel, as well as this person, to review the boxes the following week on March 12th. Although the government made available all 27 boxes seized from Mar-a-Lago, counsel elected to review only 8 of them. To facilitate the review, the government provided as a courtesy a chart listing for all documents with classification markings seized at Mar-a-Lago. 1. The room in which the document was found, including box number if applicable. 2. The beginning Bates number in classified discovery. 3. The index code assigned by the FBI, described below. 3. The number of copies of the document found. 4. The classification markings on the document. And 5, if applicable, the corresponding indictment count. This is but the most recent in a long line of accommodations and assistance the government has provided. Holy cow, dude. I'm just going to pause there. They're so full of it. The government.
That's why I was shaking my head.
This is ridiculous. The government itself has done everything possible to crucify Trump and everyone connected with him from day one, which today includes curated lists of important evidence, hard drive arrays, even provision of government laptops, all above and beyond its obligations under the rules.
Didn't they say they lied though before? So how can we trust what they're saying?
Right, exactly. I'm just gonna spin through this and see. Okay, so here's a footnote. This isn't the one. Hold on. Let's see if I can find it. Okay. I'm looking for that footnote he referred to. Oh, here it is, right here. So on page 8, footnote 3, the government acknowledges that this is inconsistent with what government counsel previously understood and represented to the court. See ergo 4/12/24 hearing trial at 65. Government responding to the court's question of whether the boxes were, quote, in their original intact form as seized.
Wow.
by stating, quote, they are, with one exception, and that is that the classified documents have been removed and placeholders have been put in the documents. All right, so that's 3. So here it is up here, again, on page 8. It's number 4, location of classified documents within each box. I'm going to read this section. Since the boxes were seized and stored, appropriate personnel have had access to the boxes for several reasons, including to comply with orders issued by this court in the civil proceedings noted above, for investigative purposes, and to facilitate the defendant's review of the boxes. I knew that's where this was going. It's the defendant's fault.
It's always Trump's fault.
It's always Trump's fault. The inventories and scans created during the civil proceedings were later produced in discovery in this criminal case. Because these inventories and scans were created close in time to the seizure of the documents, they are the best evidence available of the order the documents were in when seized. That said, here it is. There are some boxes where the order of items within that box is not the same as in the associated scans. According, and it continues, and this is where footnote 3 falls, and you go down to the bottom, and it's like, oh yeah, we said it was, but we were wrong. There are several possible explanations, including the above described instances in which the boxes were accessed. It's Trump's fault. That's what that means. As well as the size and shape of certain items in the boxes, possibly leading to movement of items. For example, the boxes contain items smaller than standard paper, such as index cards, books, and stationery. Books, which shift easily when the boxes are carried, especially because many of the boxes are not full. Regardless of the explanation, as discussed below, where precisely within a box a classified document was stored at Mar-a-Lago does not bear in any way on NADA's ability to file a CIPA Section 5 notice. And will they already have an accurate record of the boxes in which documents with classified markings were found? They don't need to do anything. It's all okay. This is garbage, dude. This is absolute trash. That's pretty much it. It's there's basically it sums with for these reasons, NADA's motion should be denied.
How is he supposed to get a fair trial?
How exactly? How in the heck is Donald Trump supposed to get a fair trial in this anywhere in this country when you have prosecutors that are willy-nilly moving stuff around, claiming it doesn't matter that the evidence doesn't match the record, Your Honor? It doesn't matter, Your Honor. It obviously shifted during transit, Your Honor. It's not like anybody went through it. It's not like anybody looked at it or moved stuff around or possibly pulled some exculpatory evidence out. It's not like that is important. These people kill me, man. They really do. And anyone, you can hate Donald Trump all you want. Orange man bad, mean tweets. I get it. I don't agree, but I get it. But a fair trial is the foundation of this country. It really does go to the core of America.
Yeah.
It really does. Innocent until proven guilty. We've seen that violated numerous times by the press when it comes to Donald Trump.
Yeah.
A fair trial of a jury by his peers. That's been violated multiple times. And Washington, D.C., Trump doesn't have any peers in Washington, D.C. All those people are gone. Zoom. Just like Fruit Loopy.
Yeah.
This is nuts. It really is. And again, interestingly enough, none of these other news sources have seemed to pick up on this at all. Ladies and gentlemen, this is what the former president is being subjected to. It is, look, it's a witch hunt. It is absolutely a witch hunt, and it is lawfare, and it is unconstitutional to the nth degree. I am truly hoping that we can get to the bottom of this and we can get back to hell. At this point, I'm just going to say it. I could go for $1.59 gas and some mean tweets. It's just that simple. I don't know if this garbage they keep throwing, they just throw everything at the wall and hope something sticks. I don't know, man. He might rise above it. We'll see. His popularity has soared in lots of areas.
Yeah.
That he had trouble with in the past. So.
A lot of people are seeing through this.
Yes, thankfully. Yeah. Thankfully, because one of my concerns was with all the crazy media coverage and all the people, doing what they do, to try to make it seem like, he's the Antichrist or whatever. Are people going to see what's happening? And I think many are, thankfully. So, ladies and gentlemen, that's it for me. Hope you have a wonderful day, and we'll talk to you again very, very soon. God bless you. God bless Indiana, and God bless the United States of America. Have a great evening.
If you'd like to support the show, please visit our Patreon at patreon.com/Dion's Daily Dose. This has been Dion's Daily Dose, hosted by Dion Bergeron. Executive producers, Sean Holgram and Michael Beebe. Copyright 2024. Dion's Daily Dose, all rights reserved.